Hi everyone. So we are here. We are here in conversation with Pradhyuman and Vasanthi from GNLU, who are in their final year of undergraduate program. I am joined by my one of the team members from Criminal Research and Review, Pratyusha, and we'll be talking about UUC Regulation, POSH Act, and in general POSH policies in not only law schools but in general universities and colleges across India. So, Pradhyuman and Vasanthi, you guys have worked on you guys have drafted a policy for GNLU and submitted it to the college, which from what I know, college is yet to respond on it. Could you guys please, take us through the work that you did and what were your objectives when you started it, and how did you approach the work? We can start with maybe Pradhyuman first.
Yeah, thanks, Ashwani. So, I mean, the reason that we even decided to look into this issue was because of the regulations that exist in GNLU to address these issues. After the POSH Act was made in 2013, every workplace was required to comply and make a legislation to have an internal complaints committee and all of those things. So that was done. But the thing was that some institutions, some people don't know, is that the UGC had also come out with similar regulations in the year 2015, which were meant to specifically regulate universities. So what they did was, in some ways, they modified the POSH Act 2013 and made it a lot more appropriate and specific to, the needs and requirements of universities. So that is something that requires mandatory compliance over and above the 2013 Act that our university has admittedly not done. So that was what actually prompted us to, begin this exercise. I mean, we ourselves being students at the time, I mean, we were at the time in the fourth year, so not like we knew a whole lot about legislative drafting or anything like that. So the best thing to do was to take a template of the 2015 regulations themselves to just make a checklist and make sure that all of the mandatory requirements are being fulfilled. And then we thought about, adding things over and above that weren't really mandatory. So starting with the 2015 regulations, we made that basic template. After that, we looked at different practices in different universities, saw what could be done in our context, what could be added over and above that bare minimum. So yeah, I think it was more or less the task of identifying the best practices. I don't think we ever sat down and by ourselves came up with mechanisms. I think that the most practical way for us and to complete it in a time-bound manner, we just looked at other places and made the policy. So that was basically the approach. I mean, the objective was to actually get the university to satisfy the bare minimum. We weren't being very ambitious to try and have this comprehensive policy. We didn't know what the scope of it would be ourselves. So yeah, I think that's basically what we did. That was the objective that we had. Yeah.
And like to add to that, so when we drafted it, that was the resources that we used, but we also I know the scale at which you're trying to do it, Ashwani, we did a very minimal level questioning of what are the issues that people are, what do they think is the issue with the existing policy, or like in general sexual harassment policy in universities, how do they think that things can be changed? So we tried to look at those specific issues as well. But we didn't get a lot of responses. We were also operating on a very limited time frame, so we didn't push it more than maybe we should have. But like at that time, we were just trying to finish it, and we finished it. So we did the drafting, and actually we did like talk to the VC and everything. It's just that we haven't been able to get anything out after that particular session. So and we also had to we also spoke to some of the practitioners, as Pradhyuman mentioned in the beginning, to help with the drafting. Like Chetna, who is also going to conduct a session for you, she was also a part of it. We approached one more alumni, actually two more alumni, Bishwa Prasad and another. We also organized, we also spoke to Himmat, which is an organization that has also released a very illustrative handbook for people, for university students. So yeah, so that was the scope of the research, I think. Yeah.
Thank you. Pratyusha, you have anything to
Yeah,
add?
so I mean, over the course of the policy formation, as you said, you referred to different POSH policies of university. Was there any particular flaw that you identified during that course, something that you feel should be addressed in like POSH policies in universities in particular?
Pradhyuman, you want to take that? Yeah.
No, you go ahead.
Okay, so so we considered the POSH policies of major national law universities, and we did look at some general universities, but mostly like national law universities, and they mostly like the good ones were able to cover some of the bare minimum requirements, but where we thought they lacked, or this was, I think, our opinion and like opinion of most people nowadays, is that they were mostly just for women, and there was often not much like the good ones obviously dealt with like students and all types of sexual harassment, but then there was this lack, like it didn't address this specific issue of what if it's the other way around, or like what are the gender dynamics, what is the situation if you do have such a thing, what are you going to do about it, like. So that was one thing that we thought was a major flaw, and we also found that if they were in compliance with all things, that was one of the things that we thought could be improved, but what we also saw was that they were not in compliance, or they had a lot of timelines which were not meeting. Like either it would we struggled, not we didn't struggle, okay, we had a little issue figuring out what timelines to adhere to. Like I think we leaned towards the UGC in the end, but yeah, so we were trying to set, like sometimes they would say 90, sometimes they would say 60 days, because there was a certain part where we thought they conflicted between the UGC regulations and the act. So yeah, that was, I think, two things that we looked at. Like if that's okay, I think we can also make reference of note. They had a safety
Vasanthi,
like they had a
could you please repeat that last part? What you were
Is it clear now?
referring to?
I
Yeah,
got
yes,
a notification that my internet connection was unstable.
It's clear now.
Is it
It's clear
fine
now.
now?
Yes,
Okay,
it's fine now.
So I was just saying that, like, like if I know you asked about a major flaw, but like a positive thing was, I think, the NUJ's policy, which provided for a safety cell or something. They had a committee, like when you have an ICC constituted, you can also ask for someone to support you, like a support person. Yeah, it's called a support person, I think. Yeah, yeah. So that was a good part about that policy. So yeah, I think if I missed anything, Pradhyuman.
No, yeah, that support person mechanism, and yeah, there's basically the checks and balances on the timelines was an important aspect. And yeah, I mean the duty to create awareness, I think that was one other thing. So yeah, these small things. I don't think that coming up with these policies is like the toughest part. The hard part is actually getting the universities, the institution to actually implement. And this is something that even I saw across most universities, if not all. Like the policies, they were well intentioned, but the thing is that you shouldn't like just sit on it. You should actually act and show that on the ground. Yeah, and even for our university, when we actually had our conversation with the administration, we were told that the UGC regulations were actually being implemented, and that the ICC was constituted as per the latest guidelines. It was just that the students weren't informed or had absolutely no idea about the members. So it's not that, I mean, technically, if you look at it from a legal standpoint, it's not that they're not complying. The other thing, I mean, at that moment, we realized that there's a whole other dimension that we aren't informed. So what is the point? we don't even know what our remedies are as students. We don't know where to go, how to file a complaint, what are the options available to us. So apart from, even having these laws implemented, we should actually be aware, and that step should be taken from the side of the university themselves. And like, if you actually take a look at the UGC regulations and even the POSH Act for that matter, they don't say that the specific workplace or those universities are supposed to make regulation. What they're saying is that you have to have an ICC which has the so and so composition. You should have such and such mechanism. These are the procedural safeguards of filing a complaint and all of that. So it's not required that a university comes and makes a law to that effect, right? What you have to do is actually comply with it. So the regulation can be, say, the UGC regulations themselves or the POSH Act, and what you have to do is actually execute. So I think these two aspects need to be given separate attention. One is that you should actually have those policies in place, and the second is actually, make an effort to create awareness and ensure that people know what's going on.
Yeah, and another thing that we also noticed was that there was no information about like what kind of training the ICC is receiving or anything like that. I came across this I don't know if it was called the Mind, I don't know. So yeah, there was this organization that was conducting ICC training. So we want our ICCs to be trained also. We want them to be sensitized. So that was something we felt like we should be informed about. I feel like that information that, yeah, our ICCs are functioning in a way where they are, equipped to deal with these issues. That is also something I feel like should be added to the awareness aspect of things. So yeah, that was, I think, something we didn't really see. So maybe you can consider it as a flaw of the policy itself.
That's a really good
Actually,
point. So
I'm sorry, I'm cutting you off, but just to add to that, it's not, I personally feel that the policies can at max tell you that such and such condition is mandatory, and what will happen if you don't follow it. Like, if you look at the very end of the UGC regulations 2015, it tells you what the consequences are if the universities don't comply with those mandatory requirements. And they're actually quite, I wouldn't say extreme. Extreme would be a negative term. They're appropriately, quite extensive. So things like derecognition of the university. So if it's a state, then that recognition goes. Then cessation of all sorts of grants that the center or the state government can give to it. Then it would be mandated that popular newspapers and public notices be issued that that particular university does not have a zero tolerance policy towards, sexual harassment redressal mechanisms, and things like that, and where your entire funding can be possibly cut off, your recognition can be taken away. That is the consequences. And I think they've also given a specific timeline. I think it was 2 or 3 years, Vasanthi can correct me, that you have to actually comply with the UGC regulations. So it's not that the people who made these policies, the UGC regulation itself did not have a picture of the importance and what it would mean for students and for everybody involved to have these policies in place. It's just that despite this, even the UGC has shown a very, not a very serious attitude towards making sure that there is compliance. So yeah, I think what has to be done is from the side of the universities and the institutions themselves, and there's only so much that the parent legislation can do.
Yeah, because they do have the compliance requirement. They have a yearly compliance requirement. They're supposed to show like number of cases, number of complaints, whatever they did, what are the remedies that they issue, the ICC has issued. So they do have these supposedly fail safes, but then, yeah, like you said, there needs to be some more stricter look at it. So yeah, that could also be a point.
Right. Thank you both. Those are some really good points, inputs, and we'll talk about a few of them in a bit more detail. So just to reiterate a few points that you would talk about. So Vasanthi, you mentioned about safety cell and support person. I think if I'm not wrong, I did read in Saksham report that they had recommended this thing. I'm not sure whether it's there in UGC, but it is one of the recommendations in the Saksham report to, to the extent I know that this is something that could be added, and it's really good because after when a victim has filed a complaint, what they face, right, after making a complaint is something where whenever they are outside in public or an outside in public domain, they are like, you could say that they could feel that others are looking through that that sort of lens that, okay, this person has made a complaint like that, right? So they could say it makes them more vulnerable to any sort of, right, so being in public domain. So, and even when they're filing a complaint, or you could say they want to approach someone to maybe talk about it, or to prior to filing a complaint, this support person or self the safety cell that you talk about could come up and help them out there, right, to figuring out how to proceed and how to, because that period of like when they face sexual harassment, and when between the gap when they face and when they file a complaint, this period could be really, I don't know, it's difficult to for us to comprehend it. It's only someone who has gone through that phase can understand. And so that's a really good point that you mentioned there, and something that always should focus more on. Another point that's really important is training given to ICC members, because we talk about when we talk about awareness and all the things and training, we often there some colleges that I don't think colleges organize firstly awareness program for their employees, and so they, even if some of them are organizing, it's just about giving to telling the employees what their rights, obligations, that they have to comply with these laws, regulations, what constitute maybe sexual harassment, and whether they are, who all are covered within these laws. But I think it's very rare for colleges to have training sessions for these ICC members, so that they can they know how to handle a complaint. Because so in the earliest in the session that we had with Shivangi, she did mention that a few instances of that she knows from some colleges in India, that when victim they are placed before the ICC, maybe for some maybe the ICC is hearing their side of the story. One of the very first question is about what were you wearing on that particular day, and that's not something that you ask someone, right? What does it have to do with what they have faced, right? So it's the very you could say very insensitive way to go about a complaint. And that unfortunately that does not come as a surprise. It's not surprising to hear that is happening in Indian universities, colleges. So given that, how do you think that that obviously the training is one way to go about it? How do you think that colleges could focus a bit more on that how ICC should function? One of the questions that I would like you guys to answer is whether we should have a more independent members from outside college, because we just have one member who has to be from some NGO or some social, who has done some social service, right? And is aware about these gender issues. Can we increase that cap? Like maybe have a few more members to from outside, and maybe not have as many members from the administration, especially when someone from the admin is involved in the matter. Maybe you can start with Vasanthi first.
Yeah. So yeah, okay. So when you have the composition, I mean, I don't think we can really say let's not have enough members from admin, because that is the requirement of the regulation. So we can't cut down on anything that the regulation prescribes. So we have to go with that. But then
I'm sorry to cut you off. I'm aware about that. I'm saying that if do you think that the regulation itself should be changed and to give more, you could say,
okay.
Yeah.
Mm, you could, but I think that when you have an ICC that's functional in the university, and you want that ICC to work, like be there whenever there is a particular situation, and like whenever there is a complaint. I'm not because I don't know, in our communications with like resource persons and all, we feel like everyone's really, has a lot, like is busy, and then they're not really able to make the time out for it. I don't know if that's sufficient reason to say let's not have more independent members. Maybe I feel like that's a practical issue there might be that whenever you have a complaint, there might be delays because a member of the ICC is not available. But then even in that case, we do have a quorum. So I'm just thinking out loud here. I apologize that it's, kind of haphazard, but I feel like having those members from the university is not a central issue, I feel. But if the regulations are somewhat complied with, I don't see a major problem with it. But I definitely see value in maybe incorporating more members from these social organizations. And it would be great if they actually implemented the student requirement as well. So like I feel like if they did that, if they had more student members, and if they maybe had one more or like two more, I don't know if, but then the thing is you keep increasing the quorum and that becomes a huge problem to the process itself. So you don't want that as well. So I feel like the regulation as it stands can work if it's implemented to the extent of you having the student member and a proper functioning independent member. So if that is there, and also most importantly, the admin member should not be someone connected to the VC or like an administrative position. I feel like that is something also they need to keep in mind, and because it has been seen that that is an issue, like that is something that happens, or either the university does not, like maybe has skipped over that part of the regulation that says maybe that should not be there, or maybe it's, I don't know, whatever the reason that happens. That's something also I feel like maybe to my view, I feel like the regulations are not, I don't see a need for change over there as long as it's implemented properly, having the student members and the independent members. So yeah.
All right. Before we go to Pradhyuman, I have just one more point to add here to what Vasanthi has said about, like I said, like Vasanthi also agrees, even though she has concern about increasing the quorum. She is a bit more lenient now that we can have maybe a couple of, maybe on one more, independent member. And I have to add one point there that maybe we can do that, especially when the call is about, let's say, I'm really sorry to all tech colleges that they lack social awareness. Firstly, that's something that I found, that is, so especially when we're talking about that, those colleges, when technical aspect, when they're not, you could say, not you could say exposed to humanities side, right, a social side of of law or in general, right? So especially with those circumstances, maybe we can have some more independent members who can bring, you could say, the who are, you could say, a bit more close to how law functions, right? So with that, I'll move to Pradhyuman, and then we'll take any comments from Pratyusha if she has any.
Yeah, I think I completely agree with Vasanthi on everything she said. And the one thing that I definitely like to add is, the requirement of having 9 members, which I think is what the UGC regulations provide. When a person goes through an experience like sexual harassment, I don't think it's easy to even talk to one person. So, presenting yourself, going in front of a panel of 9 people, all sitting in a room who are supposed to listen to every party involved on every witness involved, and that entire proceeding should happen in one go, ideally. So, having that many members, I think firstly is wrong. Then the second aspect that we have to look at is, whether the majority of the composition of the ICC has proximity with the institution, because what we're talking about is harassment that takes place in what we have defined in our regulation as campus. Okay, so it's not something that happens outside of university and is unrelated to it. You must be in your capacity as a student to claim the benefit of these regulations. So even in cases of administrative law in general, there is this concept which is actually not gained recognition in India called institutional bias. So just by virtue of me belonging to a particular institution, some authors say that I have this subliminal bias towards protecting its integrity, its reputation, etc. So even if I'm not particularly friends or enemies with any employer, any other member of the administration, I will still associate myself with that university or that institution because that person is involved in that institution. So from a purely policy perspective, I think that institutional bias needs to be accounted for in some or the other way. And the way it stands right now, I think 5 members are from the university and 4 others are outside of the university, where I think it's students plus 1 NGO. Vasanthi, you're muted.
Oh, yeah, it's like 3 student members. Like what we finalized on was 3 student members and one
so basically,
independent.
Yeah. So it's 4 people who are not associated with the institution, and there are 5 who are associated. So I think perhaps there could be a change in that. I mean, firstly, we should reduce it from 9, in my opinion. And secondly, this balance, this majority needs to be kept in check because of this entire issue of institutional bias. So I think, if we actually implement whatever is prescribed, I think it's going to be the biggest advantage. Again, I know I'm repeating this, but even if this requirement of 9 members and all of this is actually followed, I think that we're going to go a long way. And we're talking about all of this in the context of independence and to ensure that there are procedural checks and safeguards. I think one other thing that we have also included, and it's one thing that the handbook to the 2013 Act also provides. So once the I'm calling it the Vishaka Act, the POSH Act was enacted, the ministry had actually come out with this guide, or this sort of handbook, I suppose you can call it, which had pointers as to how you should go about conducting this entire procedure. What are the considerations that the ICC members should have, and when you're making a decision, the reasoned order, and this is how they framed it. They've said the decision should be reasoned, and it should 1, 2, 3, 4, 5 account for how they've actually come to that decision. So Ashwani, you had at one point spoken about actually having some sort of mechanisms to inform these people, make the members themselves aware about how to treat these sorts of complaints and how to be sensitive to certain things that they are mostly not. So I think this is another very effective safeguard to ensure that the decision that is being made is actually well reasoned. It is accounting for things that cannot be subjective. You cannot feel that one person feels one way, one person feels the other way. There should be some sort of objective satisfaction. Now, admittedly, these guidelines and this handbook does not have the force of law. So that's a big disadvantage. And I think the UGC regulations anything at all. Have to actually ensure that everybody involved, all the stakeholders are not subjected to arbitrary decisions.
Yeah, this handbook actually was, it had information on how the witnesses are to be questioned, what kind of questions are you going to ask them, what are your considerations and things like that also. So yeah, I think we did consider like putting it in the policy that we were trying to draft, but we didn't put in everything. We just try to limit it to having a reasoned order, which is, as Pradhyuman pointed out. But definitely, yeah, maybe some institutional mechanism for that could be helpful. And also, actually, maybe like, I don't know, you mentioned what constitutes sexual harassment, and it just kind of like ticked off a switch. Like I was thinking we deliberated on that quite a bit, because Pradhyuman used to often just like find these judgments, and we spoke to the resource persons that we had contacted as well about what constitutes sexual harassment has been sort of narrowly, maybe, I don't know, if I'm taking this discussion off track, we can come back to it at some point. I just wanted to point out that the definition of sexual harassment also is a possible flaw in most policies, because it doesn't account for what sexual harassment is today. Like we have this notion that sexual harassment has to be something lewd, or like it has to be something physical, or like all of those things. But that is also something maybe we can come back to if I'm taking this discussion off track. So yeah, I just wanted to point it out, and before I forget, because I did forget it at the beginning. Yeah.
That's a really good point. Pratyusha, you have anything to add?
Yeah, I mean, just in that context, like the definition of sexual harassment is pretty narrowed down in all these rules and norms that we have. Aside from that, what is your take on like general sensitization, not just of probably the ICC members, but also of students, like as they enter the university, just of these rules and regulations, as you also noted that they aren't openly available, which I think is a requirement, I suppose, that these have to be notified also adequately. So would general sensitization actually further the purpose of these POSH policies in universities?
Definitely it would. So how they have a lot of these orientations in the first year, they like talk to you about different committees, and they talk to you about anti-ragging, and anti-ragging has sort of become common. It has become something that the university wants to combat, at least so far as my experience has been. I know that it might not be true in practice, but at least to the extent of talking about it, having a committee for it, and maybe like talking to first years about it, at least that to that extent it's been there. So I feel like that is a good step. Maybe in the first year you want to introduce student every year, actually, so it's not just the first year students. Every year you can maybe like talk to students about it, tell them, hey, this is the committee we have in place, these are the regulations that are applying to you, these are the mechanisms you can use, like not just institutional mechanisms, you can use these counseling facilities and other things. Like, so the university can also provide resources, like not either they provide resources, or they at least direct you to someone who can provide you resources. So for example, we in our experience, we see that there's not a full-time psychologist or a counselor in most universities. So I feel like maybe that is something that can create this person, whoever is going to be a part of the university, can conduct these sessions. The ICC chairman can conduct the sessions. So that we know that these institutional mechanisms are in place. And you can resort to non-institutional mechanisms in case you are apprehensive of approaching, which you want to obviously eliminate, but in the beginning stages is something you can consider. So yeah, definitely sensitization is important. And that's why I pointed out to the Himmat illustrative handbook, because that's so accessible. We also did our handbook. We took our help of two third year students who are currently, I think, in the fourth year, and no, one fourth year and one third year student. Yeah, so we also tried to create this illustrative handbook, because I think the idea is really important, that student, if they want to find out something, they shouldn't have to go through UGC regulations and the POSH Act and even the GNLU regulations. As law students, it should be natural for us to do that, but even first year students, right? So you want them to have access to this information easily. So an illustrative handbook also could go a long way in the sensitization process. So yeah, that's about it.
Thank you, Vasanthi.
Yeah,
sorry.
I just also wanted to say, I don't think I don't think sexual harassment definition is. Am I cutting off again?
No, we can
I
hear
think
you.
it's Ashwani's connection.
Yeah.
Oh, okay.
Yeah.
Great. No, I was just saying that I don't like it's not that the sexual harassment definition is narrow, because there are so many subparts to the definition. It's just that like we added all of it. We added all of it, and then we had to like reduce because it was repeating. But yeah, so we notice that it's narrow in like concept, because it does cover a lot of aspects beyond, like it does cover like stalking and like voyeurism, and like even like if you're like emotionally like sort of threatening someone, but then it doesn't cover the kind of sexual harassment comes with like against a person, because you know what you say. Okay, so maybe Pradhyuman can better explain this, because he like we looked at like certain judgments and everything. So yeah, Pradhyuman, you want to take that?
Yeah, so I think the first thing right off the bat that I had a problem with when I read the 2013 Act was that the aggrieved person can only be a woman. So for an institution that does not have anything similar to the UGC regulations, which is gender neutral, a person, a male, is absolutely remediless, right? So that was one of the biggest things, and the primary thing that we pitched to our administration as well, that please see that this, we are not just arguing over these niceties and small peculiar things. The impact of not having the latest version of the law is that literally more than half of your population is basically at sea. You don't know what to do, where to go, and even if you're aware, I mean, it's not practical to suggest that a person go to court for things like this. So we really need to firstly make it gender neutral. So in the process of finding the best practices from across universities, the first thing that we noticed was that the definition of sexual harassment in the UGC regulations is exhaustive. So I'm going to be a little slightly technical here. So if it's getting a bit too technical, please tell me. So the definition in the UGC regulations of sexual harassment is exhaustive, which means that unless and until that activity is coming within one of those identified circumstances, you're not going to be covered in the UGC regulation. And in the POSH Act, it's actually inclusive, which means that it is capable of going beyond the explicitly mentioned circumstances, right? And if you actually look at the entire history of the POSH Act, why it was enacted and what was India's stand in international law, etc., you will see that it is actually in furtherance of our international covenants and in furtherance of the objectives of Article 14, 15, and 21 of the Constitution. And these are things that are actually expressly mentioned in the preamble of the 2013 Act as well. So if you actually look at these international conventions, you look at the Constitution, Article 14, like we all know, speaks about the concept of equality, right? Does not expressly speak of life, liberty, and things like that. So, I mean, what the 2013 Act sought to do was not to just talk about, sexual harassment where there is some sort, like Vasanthi mentioned, there's some physical, activity or some sort of actual physical assault. What is also ideally required to be covered is any sort of discrimination, any sort of harassment or unpleasant conduct which is based on the sex of a person. So that is how I think sexual harassment, the expression, should be rightly construed. And this is not something that we just came up with. This is actually in the form of a Supreme Court judgment, which was given in the context of discriminatory treatment that a raw officer was actually subjected to. So she filed an application under Article 32, went to the Supreme Court to get all of this resolved. So in that process, I think it was admittedly the arbiter of the case. The case that I'm talking about is Nisha Priya Bhatia versus Union of India, right? So the arbiter of the case was that the 2013 Act was actually enacted to account for the larger issues of structural and institutional discrimination faced by women. So even if things like catcalling would also be included. So one thing that Vasanthi mentioned was stalking and voyeurism and things like that. So that is still one level beneath explicit sexual harassment as we conventionally understand it. What I am saying is that even something much more milder than stalking would also come within it. So, for example, there's a professor who's just treating a person differently by virtue of the fact that they belong to one sex or the other would also technically qualify as sexual harassment. So sexual would not be, based on, prurient interest, a very famous phrase used by the Supreme Court. It doesn't have to be sexual in that sense. Sexual here means with respect to the sex of the person, the biological sex of the person. So any sort of activity that has the color of sex is included within the 2013 Act's definition of sexual harassment, because like I said, it's not exhaustive. But this has completely been narrowed down in the 2015 regulation. So another issue that Vasanthi and I faced was the constitutionality of the 2015 regulations themselves, because if there is such a comprehensive legislation to account for institutional issues, how can a delegated legislation narrow down the scope so much? So yeah, all of these are conversations, and it is always open to universities themselves to have comprehensive regulations that go beyond the UGC regulations, which is why we push for a very expansive definition of sexual harassment. So yeah, from a legal standpoint, all of these issues are there, that you should have sexual harassment definition be inclusive and have it be as broad as possible in the context in which the 2013 Act is actually enacted.
Thank you, Pradhyuman, for the elaborate description, and it's really good to have, to have that. One more thing that I'd like to, one thing that I would like to refer to is the sexual harassment definition of sexual harassment in the UGC regulation, and the second part of it, which is, I think, mostly talks about explicit and implicit sexual undertone. I'm not sure to what extent it covers that, to what you were talking about. It does not cover like what we were talking about, that if there is something comment with regard to biological sex of that person. I think so that's something you could say a very advanced definition of sexual harassment. It is not covered here in the regulation. Maybe we can have an open phrase for this term and for the definition, and not make it exhaustive, like I said. So yeah, that's a good point.
Actually, just one more thing. So yeah, and also like it's beyond that, there was also like the things was that you consider think that time of our drafting, like we had friends who were working on that as well, and they had come out with a policy which I'm sure you've seen as well. So we also thought that there could be some form of sort of like joint strength to both those policies that the university can give, and also like to point to like a distinction in that the conduct by a professor. Like, so the regulations in the Act, they do, like, as you know, they do cover where a professor might, like in for example, a professor who is going to use the power that he or she has with over a student or a or a PhD student or anyone. So that is covered. But then what is not covered is what Pradhyuman mentioned, when you have that discrimination aspect of it. I don't know why the word discrimination just slipped my mind. Yeah, so that is something. I just wanted to point that out. Yeah.
Right. Thank you. Thanks for that. Pratyusha, you have anything to add over here?
No, nothing further. I think we covered all relevant points regarding the policy comprehensively.
Okay, just a couple of things that I'd like to come back to is about power dynamics and conflict of interest. So, I mean, it's something that's very, it's general and it's common, and it will be there no matter, because it might differ from case to case basis, right? So if, let's say that I'm not sure, please correct me if I'm missing something over here. I'm not sure whether the regulation gives any sort of scope that, let's say, someone, if one of the member on the ICC panel is in, let's say, a friend with the alleged offender, is there any way that their membership, or like the students or even the employees can, you could say, make a formal maybe request or like sort of request to the ICC to to remove that person at least for that particular case. So I'm to the extent I know, I don't think there is any formal way to make such thing. That always there could be informal pressure group that they can create a person on ICC to replace someone for that, maybe it's just for that particular case. But something that could be added over here is that if they want to, that if we have a problem with one of the members because they are maybe like Vasanthi said, that there is no clause that which stops someone who is doing completely administrative work to be on panel, right? So someone who is very close to, you could say, college admin should not be on panel because they will obviously see from that institutional bias, right? So maybe we can have something, a clause on something along those lines if it is not already there. Correct me if it's there. One thing over there. One more thing, that because there will always be some, because if let's say if the alleged offender is one of the faculties, the friendship part, it's almost impossible to rule it out because obviously they are, especially in colleges which had a very, you could say, 30-40 faculties, it's very likely that most of us would know each other and some of us might know each other very well. So maybe it's most cases, or in some cases it's not, it seems almost impossible to replace someone with a better option, right? So do you have any suggestions for such problems, or like how to deal with that? We can start with Vasanthi first, maybe.
Sure. So we also considered this actually. So Pradhyuman came up with this, like we used a draft where we drafted a provision for disclosure. So this exact same issue where you do have some form of conflict, there can be a replacement for a member of the ICC, and this is something that we did see, I think, in one of the drafts that we were looking at, Pradhyuman. We did see that, right? So we
I don't think there was a mechanism for replacement. Disclosure, there might have been, but yeah, it just said that you had to disclose so and so, but nothing beyond that, I think.
Yeah, so so you can have like a provision where you have a disclosure of in the beginning itself that you do, whether you have a conflict of interest or not. So this is a responsibility on the part of the ICC members. And then you can also have a mechanism, like you said, which is to file for a complainant to raise an objection to a member of the ICC. But then again, Ashwani, the problem here would be that, see, you do have members of faculty, and it is possible that there is the perpetrator is someone that is in the faculty or someone who's in a security, like in an official capacity, because that is usually the case, that there's the power issue there. So I mean, you'll have to see what is the nexus over there, like what is the extent of the bias that you assume. So that's why we thought that there should be some form of a hearing. So there's like either you automatically say I cannot be a part of this particular hearing, or you have a hearing over that particular issue. So yeah, that is something that can be in that we actually encourage universities to consider adding to their policies in more detail, like, because you can obviously say, because most of these regulations and the act will say, hey, principles of natural justice, follow it, like you shouldn't have conflict, but obviously it would help much more if there is a detailed provision for like either recusal or an objection to be raised. So yeah, definitely something that can be added. My memory is not clear on whether this was something that was already there in the regulations or the act. Pradhyuman, I'm not sure.
Yeah, I don't think the regulations in any way accounts for any of these things. And like you said, that it's possible that you have a hearing where there's a challenge to the bias, the existence of bias or not. But I personally, even at the point of drafting, felt that universities are not going to buy this. They're not going to have one set of proceedings going on here, and then that would conclude. You'll have a panel of members constituted for that separate purpose. It would just be just practically not feasible. So the thing that we did was actually have a twofold mechanism for disclosures. Okay, so I think the first of the two that I'm going to talk about is what some other policies and public discourses have spoken about, is about whether the member of the ICC has been convicted of any offense before, if there's any inquiry pending against that person, if they have at any other point abused or taken undue advantage of their position, things like that. So, very, very general things that would affect their capacity to make a good decision. That would be one aspect of the disclosure that I think other places have spoken about. What they haven't spoken about adequately is the second aspect that Vasanthi also said, was about circumstances which can, indicate friendship or any sort of relationship with any of the parties involved, be it a witness, be it the victim themselves, or another aspect that I don't think is given enough importance, and a lot of litigation that is actually done in respect of, is the amount of time that the member of the ICC can possibly give to the proceedings. So if you look at it, it's a number. Vasanthi, please tell me how many months is the total amount of time for the proceedings? It just escapes me as of now. I think it's something like 6 months, right? As per the UGC guidelines.
Yeah, I think so.
It's
We'll
in
have to
months.
see.
It's like a lot of months.
Yeah, it is.
I think
It's not 6 months.
Yeah,
I
but it's
think
quite a
it's
long and unnecessarily long amount of time. The outer limit
3
of
months, right?
3 months.
No, it's
Is it?
within a period of 3 months you have to file the complaint.
Yeah, the total, like up until from the filing of the complaint to the final decision being made.
Yeah,
It's
I
a lot
think
of
so,
time.
yeah.
I think it's roughly 6 months, maybe subject to correction. But the point is that, it is theoretically possible that the proceedings take so long. And sometimes what happens is midway, a faculty will either have some other commitments. They might get transferred. Some people, they just don't show up. So this then becomes subject of litigation, that some people say that the person who heard me isn't the person who who made the final decision. So the person who's heard me should be the one who's deciding. So if 10 people have heard me, for example, you can't have 3 people giving that decision. I mean, that's an extreme example. But even if there is a discrepancy of one member, and like I mentioned, that 9-member issue becomes even more complicated because of this, there is a possible legal challenge. And, having some sort of mechanism to keep this in check as well is also required, which is why in our, disclosure forms, something that we put in the appendix to our regulations, our draft regulations, was that you have to make one disclosure when you're appointed. So you're appointed for a period of, I think it's every year, right? So the first disclosure you should make is with respect to the first thing that I pointed out, is there any prior offense against you? Is there any disciplinary proceeding pending against you? You have to make a disclosure with respect to that. Second disclosure is required to be made when a complaint is filed. So at that point, you will disclose whether you have any relationship with the person. Is there any circumstances that exist at that time that may indicate that you cannot give sufficient amount of time to the proceedings? So that is the second, point. The second point in time in which you have to make these disclosures. And I mean, at least in our case, where we are a national law university, which is an agent and instrumentality of the state, a challenge can lie constitutionally. So if there is some sort of malafide or some sort of non-application of mind in making the disclosure, that can be challenged. So unfortunately, I mean, this is not an option available to every university. But this is a sort of check that we can have through the disclosure process. So like I mentioned earlier, institutions wouldn't be very keen on having a separate proceedings for bias themselves. But if the disclosure is subject to challenge, you can have that bias, judicial proceeding on the bias of the person be subjected to court proceedings. So yeah, this is basically what we came up with. And long story short is that there needs to be some mechanism for this. This is the most feasible one that we could figure out given the circumstances of our university.
Thank you. Professor, you have anything to add or any questions?
No, I don't have anything to add.
All right.
Ashwani, if you're talking, you're on mute. You are talking, so yeah, you're on mute.
Thank you. So yeah, one more problem that I have with ICC, and that's lots of problems that I have, but there's something that I think is that even though it talks about having 2 teaching and 2 non-teaching members, I don't understand why that that thing is there, that there has to have 2 teaching and 2 non-teaching members. I don't think it helps it to just my personal opinion over here. I do think that there should be more you could say efforts to have a diverse panel. So like even the act or the regulation do not take into account that the members of the panelists are from different age groups. So let's say that I think that's very normal for these groups to have you could say more aged faculty. I should not call them that, but yeah, I could say that I think they should have more members from different age group, and I think there should be a specific laws to ensure that the not very strong, but at least there should be indication that the college should try to have diversity in this aspect. And obviously in terms of genders, not just women, because we are, I mean, in last 2-3 years, we have evolved really not in terms of what gender means, right? And still evolving, right? We're still trying to learn, what it means, right? And sometimes we could be at very, wrong end to interpret what it's meaning, right? So I think it needs to be more diversified in terms of that. The regulation do talk about the groups which are very more likely to be exposed to sexual harassment, but they do not talk about representing those groups, to have a representation from those groups on ICC panel, right? So I think there should be more efforts on those side. What are your thoughts on it? I'm sure you agree on the diversity part as well, but if you have anything to add over here, like what more could be done to make it a diverse panel to hear out complaints from different aspect, right? So gender, age group, or any other aspect, that any other points that you would like to refer to. We can start with Pradhyuman first.
Yeah, I mean, yeah. So I think as long as we make sure that the total number is reasonable, we can probably, the next thing would definitely be to ensure that we have people from different backgrounds. One thing the guidelines themselves make mandatory is that more than 1/2 has to definitely be women. And there isn't really any mention of there are no mandatory requirements for other sections of society, right? If I'm not wrong. So I think, yeah. So, I mean, I'm actually on the fence. I'm not really sure if it would be sufficient to train people, like emphasize more on the aspect of training and making them sensitive to gender issues and things like that, or is it absolutely necessary to have that diversity? So, see, in theory, on paper, everything that you've said, but I also look at it from a very practical standpoint. What is something that universities and institutions would actually accept? So it's unfortunately, it's a very difficult conversation to have. It shouldn't be, but they're just averse to any sort of extra effort that they have to make for these kinds of political and sensitive cultural issues. So I mean, I would personally try and see if it's possible to mitigate all of these issues through training and gender sensitization. And if only if that is not inadequate, I would like try and make some sort of mandatory provision for involvement of people from different backgrounds, because this is again subject to those such people even being a part of the population, right? So I mean, I can give the example of my university. So a person from a certain community or a person from a certain religion, there are extreme cases, as in there's an extremely heavy majority, there's an extremely tiny minority. Apart from that, the willingness of the person to participate should also be there, right? So from a practical standpoint, if you make a mandatory provision for a person belonging to X community, yeah, you'll have to take into consideration all of these factors as well. So from a purely practical standpoint, I think that we should try and see if this can be resolved through other mechanisms. Otherwise, yeah, it definitely makes sense and it should be done. Yeah, that's basically.
Before you go to Vasanthi, I've just one point that I'd like to add over here. So I agree with what you said, that it should not be a mandatory clause to have representation from all communities. And I have problems with a major problem with representation in sense that it often becomes just on paper compliance and not something that we really care about. So when we have this mandatory compliance, I have seen that at least in some cases, that whenever they not just this the POSH policy or ICS panel, in general, to having representation from a different aspect of different communities on in a panel or in a group per se. So whenever there is a mandatory clause, there's a very tendency that most often it happens that we have people just to satisfy the compliance, and very often, like what you talk about, it's possible that even if someone coming from that particular community or from or from some specific gender or sexual orientation, it's possible that they might not be sensitive towards these issues, right? So it's one thing to have this compliance. It's also one thing to train to have training on sensitivity, right? So that's also one thing there. So it should not be a mandatory. Obviously, there's like you said, that sometimes it's not possible to have a representation because there is no one to represent from that particular college. So that thing is obviously there, and like I said, it should be more of an indication that colleges should look forward to. With that, I'll move to we'll move to Vasanthi to take her comment.
Yeah. Again, so I think you can definitely have a requirement for representation, but going back to what Pradhyuman said, I feel like it's a difficult task, and I know that shouldn't be a bar to have a more diverse board, because that's obviously going to that is going to show some improvement in the way the process functions. But I think that the practical aspect of things, I think is a very important in how. So I feel like, yeah, you can definitely go for it. And I don't think there would be any issue from the regulations or the act, but like as a positive measure, yes, I think you can have that. Yeah, I think you can go for that. Yeah.
Thank you. So I'll just move to Pratyusha, and this time you have to make some comment over here with regard to. I'm looking for something like.
Regarding this, definitely, like being a part of GSF also, we've dealt with this time and again of the requirement of general sensitization, and aside from that, having a policy enacted. But again, I do understand that there is essentially a difficulty met from the administration side, because these topics are not something that they're very open to discussing or to deliberate on, like inclusion and just culturally sensitive topics, as Pradhyuman highlighted. So yeah, I do understand that it is definitely a positive measure. These regulations would affect the overall scenario in the university, make the regulations more inclusive overall. But again, when it comes to the enactment part of it, it may seem a little ambitious, as I think you even mentioned at the beginning of the entire discussion about how you aim to keep these regulations as accessible to the administration in a way, so as to receive acceptance from their side and not be too ambitious with the policy. So in that aspect, it may require like a lot of discussion and may take time to deal with the admin overall in this topic particularly.
Yeah, and
Thank you.
like I feel
Yeah,
like,
sorry.
so just to add to what we were talking about with respect to more sensitivity that can be achieved through representation, I think that could be something to aim for, but it's not about just making it admin friendly or anything like that. It's just to make sure that the policy as it stands is functional. So it's not about not being ambitious or anything. It's you can definitely push for change. That is something we anyways do every time. Anything that comes up in any scenario, you are looking for ways to make it better. That's essentially how we are trained to think, because you are critical of judgments, you're critical of law. So it's always something you are going to suggest change for. But I think that when it comes to the representation aspect, it could be it could jumpstart the process to make sure that sensitivity is something that's inherent in an ICC. But I feel like beyond having to expect that someone from a particular community is the only person who's going to relate to a particular struggle that someone has faced with respect to sexual harassment on campus is just, I feel, shouldn't be the aim. It should be the aim that everyone is able to be sensitive to that situation. So that's why training, like Pradhyuman mentioned, is important, and that is something we should focus on. So in our draft, we did not mandate anything, but I think I don't know if we lifted it directly from the UGC regulations, but there was a preference that like the director can keep in mind. They can ensure that those faculty members and non-teaching employees are preferably committed to some sort of a social action or some sort of organization, or like, so you want that aspect of those members thinking about these issues. So they shouldn't be completely divorced of anything that's happening in society. So you want them to be part of some form of social action. So we put that as a preference, as in it's optional, but obviously we want to see that be achieved also. So if not representation, this is something that also could be mandated. If you want, you can mandate that, or you can definitely push for that aspect of things, so that these faculty members are not just someone who's there in the institution, but also is someone who is receptive to certain social issues and things like that. So that is some way you can ensure that the ICC is sensitive.
And those are all some really good points. I'll just try to brief it and reiterate a few points. So I think we all agree that the panel should be more diversified and so to be more diverse, inclusive. But and with regard to what Vasanthi said, that them being on the panel, like what sort of Vasanthi hinted towards that, just because some is on panel we have someone some XYZ person from from a certain community or from certain gender, sexual orientation, does not mean that now that the panel is sensitive and it's all good. Everyone has to be on the same page with regard to sensitivity and their awareness about how ICC or how these policies work. So this reminds me of some project I'm working on, this personal project about it's about representation of women in judiciary, and the question is specifically about whether we are looking for representation only to fill the gaps created by the men, or male judges, because they are not sensitive towards certain topics. So we need someone who someone from a certain gender whom we expect. So is there you could say very certain specific expectation from some women, or in this context from someone from a specific community, to be sensitive towards this too? And like, do we have a you could say a separate lens to to look at these members who are coming from different backgrounds, right? So that's something that to think forward to. And obviously we agree for the fact that it should be more diversified, but it should be in more true and practical sense, and not just to make it look good on paper, right? So that's something that we were trying to deliberate upon. And we have covered quite a few things, and I'm pretty sure that if someone goes through this recording, they can come up with a policy of their own with regard to the points and the extensive points we have covered, right from those technical definition of sexual harassment to everything that ICC and constitution ICC and how it should function. With regard to, I think it takes 90 days. It's a mandatory 90 days that they have to. I just refer to the regulation. They have to finalize the complaint, hear out, and make a report within 90 days. And then they may take another 10 days to submit that report to the admin and the college, the director, and who will take further action. So really good points. If you have anything to add to, or that you think that we missed out, please let me know. I'll just wait for a few seconds if you have anything to add.
I mean, I'm sure we've already considered it because we did point to the Ministry of Women's handbook for National Commission for Women, or I think it's the ministry actually for Women and Child Development, where they prepared that handbook. So they also had like particulars that can be kept in mind while you're filing the complaint. We also saw this as a annexure in, I think, 1 or 2 university policies. So yeah, maybe just like so that the complainant knows, so that there isn't any sort of issue during the process where they feel like, oh, you omitted this particular fact, so we're going to consider that and rule against you or something like that. So yeah, just like maybe keep those factors in mind, like what particulars you have to include in a complaint. And yeah, and Pradhyuman briefly mentioned what the consequences are for non-compliance. So feel like the university policy should obviously not say we're going to be punished if we don't comply, but to say something like this is our responsibility, and to say that yes, the ICC has these responsibilities, the director has these responsibilities. So yeah, just these are some things that we didn't spend a lot of time thinking about, but we definitely did like pour over, and I feel like those are important as well. So yeah, maybe that's about it. Yeah, from my end.
Pradhyuman, you have anything to add?
No, I mean, everything said and done, things should actually change on the ground. And I think the biggest issue that I have personally seen from all
Can you guys hear him?
No, I think his screen's frozen and his audio is not there.
Pradhyuman, if you can hear us, we can't hear you. I'll just text him. So I think his internet is not working. Maybe the text is not going through. We'll just wait for him to come back. And
Sure, yeah.
Pratyusha, you have anything to add? We missed, if you missed anything.
No, I mean, like this discussion was definitely kind of really helpful into insights into the policy process of POSH, how to go about it, especially in context of universities. And yeah, it's again what Pradhyuman highlighted. Actual implementation of these policies is what matters in the end. Like seeing it in action, people being aware of it, people actually approaching these mechanisms, and approaching these mechanisms is in itself like a difficult measure in many times. So having that trust in that institutional mechanism to approach it for the resolution of these issues is definitely a, like what will show the success of the implementation of these policies. So yeah, that is precisely it.
All right. So Pradhyuman has a power cut, and I don't think he will be able to rejoin. And he says, please go ahead and wrap it up. So
All right.
it's fine. So just a couple of points that I'd just like to comment for our viewers that like we already talked about judiciary being more, that the judiciary should be more serious about, because if I'm not wrong, the regulation 12 talks about the consequences of non-compliance, right? If college does not comply with the UGC regulation, the consequences are very, even though we did not use the term extreme, but it covers almost everything that should be there, right? Right from recognition, derecognition to what withdrawal of funds, research funds, and all sort of things, right? So, but I'm not sure UGC has taken anything, has even sort of indicated some rigorous step towards those towards these directions. But I was referring to UGC website to see. I think some of you, either Vasanthi, you or Pradhyuman pointed out that colleges have to necessarily send gender sensitizing data about number of complaints received, whether it has been resolved or not, what was done, whether they have any awarenesses or not. So I did visit UGC website, I think a few weeks back, to see how many universities have actually sent data, and I could see only handful of universities were there. Fortunately, our college was there. That's a good thing to see GNLU up there. But many of the universities did not send, right? And I don't think UGC has taken even any step to approach those universities to send those the data. And yeah, so I think that UGC should be more active towards about their role and responsibilities they have. So because they are at the someone who could say sitting at the head of all these sort of ICC panels, you could say. So right, so they have to take it more seriously. They have to take, maybe they can themselves organize, you could say, zone-wise awareness session, like maybe 2-3 states, faculties from 2-3 states will be joined for a common awareness session to talk about these things. Because if they take it and make it, you could say, more not so an incompatible topic to talk about, not a taboo. So right, so colleges right now feel it unnecessary to talk about these things, that they feel that just talking about these things would hurt their reputation, right? So this has to go away. I think UGC can work towards this. So right there, I think we have talked about quite a few things over here, and this has been really productive and really good for everyone over here. And I'm so all four of us, even if Pradhyuman is not here, has something to take away from it. Our viewers would have something to learn and maybe to share this to other mates or peers. And with that, I think we'll close it. And thank you, Vasanthi and Pradhyuman, for being here. And thank you. You have anything
Thank
to?
you.
Oh,
He's
Pradhyuman is
back.
back. So I'll. Pradhyuman, can you hear
I
us?
think he's.
Yeah, I'm so sorry about that.
You're back at the at a very important you could say moment.
Okay.
We're just trying to
yeah, please tell me.
Yeah, just trying to we're just thanking you guys for taking our time, and even though we planned for just an hour, I think we have exceeded it. And so thank you for adjusting time and being here. And it was really I think every minute of this session I felt was really good, on point, technical, detailed, and something to take forward to. So I personally loved it, and I hope you guys had something. You guys had a good time here. And
yeah, for sure.
Yeah, thank you for asking us to talk to you about it, because honestly, we talked about it. We felt like we are really not in any position to authoritatively say anything, but of just our experience with this thing. So we're really happy to see your project to make some change in this field. So yeah, definitely thank you for talking, and this is nice to have this session. So yeah.